Good morning and welcome to the Court of Appeals today. I am Presiding Judge Michelle Christensen Forrester, Court of Appeals Presiding Judge, and I am joined on this panel today by my colleagues Judge David Mortensen and Judge Ryan Tenney. And we are here and prepared to hear arguments in the case of State of Utah versus West. Just a few preliminary remarks before we begin. First, if I seem a little overwhelmed, it's because it has been more than 2 years that I have had an in-person oral argument. And it's so awesome. So thank you for being here today, and thank you for attending this momentous occasion in a way. I also would like to thank Ryan Paul, who's the director of Apex, and his staff for putting this together today. It's going to be great. And just a little bit about the Court of Appeals for all those of you in the audience. The Court of Appeals is an appellate court, so we sit in judgment of what happened before. We don't take evidence. We don't we only hear arguments based on the record that comes to us. So these lawyers will be arguing that something went wrong or there was a mistake made in the trial court. And so we are constrained only by the facts and the evidence that is in the record. Other than that, I think we're ready to begin. If I could ask counsel to please enter your appearances for the record.
James Weeks with the Washington County Attorney's Office. Do you want my bar number?
No.
And Nicholas Turner on behalf of Deborah Webb.
Thank you, counsel. It appears that Mr. Turner, you are going to reserve 3 minutes for rebuttal.
That's correct.
Okay. And the clock is up there. We're used to seeing the clock, on our computer screen, so this is kind of exciting as well. Do either of you have any questions before we begin?
So the clock says 12. Are we doing 12 minutes or 15?
He's reserving 3 minutes for rebuttal. Yep. So you have your full 15. Thank you, Mr. Turner. Yes.
Well, good morning. I apologize. This is the first face you're getting outside of COVID here. Law of averages, you would have done better, but nonetheless, it's great to be in southern Utah and specifically in my alma mater. So thank you for letting us do that. But I have 3 issues that we brought up in our brief, and the first one being whether the trial court erred in failing to perform the required on-the-record colloquy as it relates to self-representation. I think it's clear that the court has a duty when a defendant tries to represent themselves to make sure that they know the dangers and disadvantages inherent with self-representation. And I believe it's undisputed that there is no colloquy on the record.
Can we talk?
Yes.
Can we talk about the dangers? Is that coming through? Okay. Can we talk about those dangers? Because one of the things the court's supposed to do is assess whether somebody understands the risks inherent in proceeding as a pro se litigant. And one of the things that's different about this case than any other case I've read is that she had a lawyer during trial, but at sentencing where she parted ways with her lawyer and the judge said, "Do you want to be your own lawyer?" She said yes. So my question is, what we're talking about is the risks inherent in proceeding at sentencing alone. And that seems to me to be fundamentally different. I guess on one level it's not, because you're clearly entitled to a lawyer at all phases. But on the other hand, the topography of what the risks might be certainly are much more grave at a trial. When you might have to make evidentiary objections, cross-examine witnesses, all of that. But but what are the risks, or do we view that any differently as sentencing? That was a long question, but that's my question there at the end. What are the risks, and why does that matter?
To answer your first question, I don't believe the standard's any different in sentencing. How you view it as it relates to the case, I think, yes, I think it does matter. And I think where the court needs to focus in Ms. West's case, if you look at the tone of both her pro se motions, her post-trial pro se motions, and the judge's interaction with Ms. West, you will see that I believe that tone had a direct impact on sentencing decisions. It is true that the state asked for 24 months and the court only gave her 18 months of probation, but Ms. West is a lovely lady. She was very fired up at this time. She did not do herself any favors at sentencing, and I think if you just a quick glance of the record of those motions and then the minutes at sentencing, it's safe to say that an attorney could have provided her with some assistance in bringing mitigating factors, talking about, a lesser sentence, but also in arguing what I think she had some pretty relevant issues as it related to those post-trial motions. There was, yeah.
I was just going to say, so let me ask you this question in this respect. Ms. West had an attorney at trial. Clearly, she wasn't particularly pleased with her attorney, but she stated on the record that, I can do better than my attorney did. And in considering the question of knowing and voluntary, isn't the more pertinent question what she knew, how she, why she felt that she could represent herself better than her attorney, and rather than sort of the prejudice that happened at the sentencing? I mean, what is the specific inquiry we are to look at?
Yeah, so there's a couple different cases on point with that, and I think one that I would ask you to focus on is the Petty case, and it talks about what, at minimum, the colloquy should address. It needs to make sure that the accused was informed of their constitutional rights to both representation and self-representation, and then determine the intelligence, the capacity to understand and appreciate the consequences of the decision to represent
But is there any question on that front, though? I mean, is there anything in this record that suggests that she was somehow unable to comprehend what was going to happen at sentencing?
I think, again, I will point back to the record. She talks about what she calls hearsay evidence. There was no hearsay objections. The motion in limine dealt with 404 A or B incidents, and it is very clear that is what she wanted the court to address. Those three other incidents that she keeps referring back to.
Right.
She mislabels them. She doesn't understand what motion to file. She captures it as a motion to dismiss. She didn't know the difference between that and a request for a new trial, a request for directed verdict, and that's fleshed out in the record pretty clear.
I mean, I think we'd all agree, I think most of us would agree that she would have been better served to have had an attorney.
Sure.
But I think we'd also all agree that she has the right to waive an attorney. And so when we look at the nature of that test, it seems to hinge in large part on whether she at least understood the nature of the proceeding and whether she understood that there was some risk involved in representing herself. Fair?
Very fair, and I would agree. I think it's important to note that while the state's brief talks about, you should, if there's a question of doubt, you should rule in favor of the state. That's
Right, but-
contrary to.
But even putting that aside,
Yeah.
she goes through a trial with the assistance of counsel.
Mhm.
She's convicted. She still has the assistance of counsel. Court schedules a sentencing hearing. She knows that she's about to be sentenced. What are we to take from the record? What did she not understand that she needed to understand in order to
Well-
validly waive this?
That's the problem with not having the colloquy. There wasn't an on-the-record examination that it deals with the minimum factors for you to review. And if you're left with that, you have a de novo review. And in that case, I think you've got to look at all the circumstances, and at the very least, any doubt should be in favor of Ms. West.
Let me ask a sort of chronologically follow-up question to that. If we accept your argument here, and if we remand for a resentencing, is she going to accept counsel for the resentencing?
I honestly do not know the answer to that question, not because I haven't asked it, though.
Right, and I appreciate it if you're not in a position to answer that. But then let me ask the sort of follow-up to my own question there. If we send this back, and then she waives the right to counsel again at the sentencing, we'll have essentially been giving her two bites at that apple. We'll have been giving her 2 pro se sentencing hearings, and that feels a little bit anomalous.
It is my hope that that is not what happens here today. I hope that you rule in favor of Ms. West, and she does take the opportunity to allow counsel to assist her, because I think that there are some, if it's all on the colloquy issue, I think there are some very interesting issues to deal with in post-trial motions with the 404 issues that I think need to be fleshed out. It's very clear, Judge Walton, who was a new judge, he wasn't presiding over the trial. If you look at the minutes, or not the minutes, but the record, he does not have any firsthand knowledge of what occurred. And if an attorney were to help Ms. West articulate what occurred and to point him specifically to why there was a violation and why she didn't get a fair trial, I think there's more than likely a chance of there being a different result.
So at resentencing, obviously, the sentence couldn't go up. That would be a due process issue. The sentence could go down, but also you could readdress those post-trial motions.
Yes, and I think it's important, obviously, my client is very principled, and she really wants another opportunity to prove her case. She's made that adamantly clear.
To prove her sentencing case.
Well, yes, to prove the fact. She's very adamant that those other, she calls them 3, I count 2, really, incidents that the court allowed in that should not have been allowed in. She felt like she was tried 3 times. I think there's another argument to be made there that I think can be very successful.
Can I take you to the 404B issue?
Please.
With a few minutes, unless either of the judges have more questions on that. How is she prejudiced by the 404B? Let's just assume for sake of argument that the 404B evidence should not have come in. How is she prejudiced? Because what I get from the record and from the briefing here is that she's caught on video essentially violating the stalking injunction. So even if we remove the 2 or the 3 404B incidents, what's the probability that she's actually acquitted?
Well, her defense is that this was an incidental encounter. She wasn't aware that Miss Law was in the library, Miss Law had her back to her, and what wasn't brought to her attention until she was almost done taping a corner of a poster, and the altercation was fleeting. She left. I think there was a total, she testified, of 12 seconds.
So the defense at issue would be what? A lack of mens rea? Or
yes, I think it would be
the
an intent.
Or what exactly is the defense?
I believe the defense is there's not an intent to violate that stalking injunction for the same reason there weren't other charges with the incidental encounters at the church functions or the community functions, where it'd be similar to if she had bumped into her in the grocery aisle as she turned. I mean, I don't believe that's a stalking violation if she turns and walks away.
Right,
There's
so-
not an intention there.
So let me engage with your hypothetical. Let's suppose they bump into each other in the grocery store. She turns, recognizes her. If she walks away, I think she's in the clear, but then if she stands and talks to her, hasn't she then committed the violation?
And that's where I think in this scenario, there is a she said argument that I think Ms. Law says that Ms. West said something that Ms. West testifies she did not say, and there's a different event. So if you're weighing it as a jury member and you just have two competing testimonies and no other outside incidents that create a pattern in your mind or confuse a lay juror that you know, maybe there's a intent there that can be inferred through multiple incidental encounters.
But is that right? Is she permitted under the stalking statute to then, to stay in the room and engage in discussion with the
No,
person?
she's not. And I believe Ms. West's testimony is not that she engaged, that Ms. Law engaged in a brief vocal interaction, and then she left, she being, sorry, Ms. Law,
Right.
left and called the police.
So to make sure that I've got the prejudice argument right, the prejudice argument would be but for the 404B incidents, the additional 404B incidents, there's more of a probability that the jury would have believed her account about the conversation. Is that the argument?
That is the argument. When you have a she said, and a very small window of time, we're talking 12 seconds, that whether she had her back to her for half, sorry, I can shut up.
But doesn't that lead directly into the substance, necessarily the substance of the reason why the state offered that 404B?
The intent?
Uh-huh.
Yeah, and I think that that's where you have to weigh, when you have, they can't just say it's intent and have it magically, okay, then we don't look at what actually happened. And our argument is that's more of a ruse, because if you look at those other outside incidents, now some of them happened after this incident. I think that's an interesting fact. I don't think it's determinative. It's an interesting fact. They weren't charged. She wasn't charged for these.
That doesn't matter.
Well,
They don't have to be charged.
they don't have to be charged, but I guess if the goal is to prove that she had intent in the library, not, because the goal is not to prove that she had intent in any of the other interactions to get the conviction. The only reason you'd be doing that is to prove propensity. And when you weigh the
Is that
probative
right?
value of that,
Is that right, though? Why wouldn't it be to go to the question of mistake? Because as I understood what you just said about the prejudice argument, one of her main points of defense would be that it was a mistake. So why wouldn't the state's response be to what you just said, that what it really goes to is to show that when she bumps into her in the library, it's not a mistake?
I think that would be more troubling if these other incidents had an element of like threat or clear intent that show that she's trying to disregard. They are in the same congregation. They live in a very small community with shared access. And the stalking injunction doesn't say you can't go to that church, you can't go to these community events. It just says you have to say 20 feet. And I mean, there's no question, there's going to be chance encounters. That doesn't mean that she's willfully disregarding the stalking violation. And to have her now have to prove that as a defendant, I think prejudices her. And
We way kept you over.
I think, yeah, so I didn't know what that clock, it was going the other way, sorry.
We
Thank
will
you.
give you your full rebuttal time, Mr. Turner. Mr. Weeks.
I'll be more nervous than the court because I've never argued to the Utah Court of Appeals, so
Well, welcome.
thank you. Just to start out, there's two possibilities that this could have gone. We could have had Ms. West continue with her attorney's representation, proceed to sentencing, file an appeal, we would have been here today. The other was what we saw. She fired her attorney, she fired the judge, she refused to have counsel reappointed, she filed her motions to dismiss, and then she filed her appeal, and we're here again in the same place we would have been otherwise. Now, both of these situations get us here, we're making these arguments, but the difference is now that the defendant tries to say that we should magically take this into a new realm that gives her greater rights and privileges because she fired her attorney and refused to have counsel represent her.
Can I stop you there, Mr. Weeks? I think what she's saying is that the Constitution entitles her to counsel unless she knowingly and voluntarily waives it.
I understand that.
And so she's just simply saying that there's no evidence in this record that she knowingly and voluntarily waived her right to counsel.
Well, and that's fine, but the appeal seems to be saying, it's this, there's an Xfinity commercial, and it shows Serena Williams and Wonder Woman, and they go back and forth till they merge together. And this seems to be a situation where they're saying, had I had the attorney, he would have argued my motions would have magically turned into motions for a new trial, and everything would have been perfect in that scenario, but it ignores Rule 11 of civil procedure that says that those motions aren't appropriate to be heard if counsel is there and they're not
Right,
signed by counsel.
But wouldn't you agree that if it turns out that she did not knowingly and voluntarily waive her right to counsel, that she's entitled to a reversal?
I agree that she's entitled to reversal to come back and to sentencing. What I'm saying is she shouldn't have greater rights, which seem to be argued here, that not only are we arguing the 404B, but we're arguing, oh, this motion to dismiss should now be turned into something that it's not.
Can I ask you a more particular legal question about that issue, the Sixth Amendment issue? One of the things that comes up in the case law about the knowing and voluntary nature of the waiver is whether the defendant understands the risks associated with having counsel or not having counsel in the proceeding at issue. Do you agree that that is proceeding specific?
Yes.
Okay, so do you agree that there are different risks associated with representing yourself at trial versus representing yourself at sentencing?
Absolutely, I agree. And one of the points that I had was, one, she was advised of her rights. When you go through the colloquy on the waiver, most of those are dealing with the trial. They're talking about, are you familiar with the rules of evidence? Do you understand?
Right,
those
so that
were
actually begs my
covered?
question. What is it in this record that shows that she was ever advised of or understood the particular risks associated with representing yourself at sentencing as opposed to trial? What can you point us to in the record that talks about that specific thing?
Well, Your Honor, page 3 of the record talks about that she was advised of her rights and penalties. So she was advised of that. As far as
And what is that from? Is that from the arraignment?
Yes.
Okay.
And as far as the prejudice that.
I'm
Do you
sorry, can I?
Yeah, by the way.
I did sit on the district bench for a decade, so I went through a few first appearances, and what we usually say is, you understand you have a right to be represented by counsel. And the person says, yeah, and then we say, do you want to have one appointed? And for example, in this case, they have a lawyer. Do you think that record supports at all the proposition that the risks and the Frampton, basically, factors of self-representation were explained to her at the front of the case? I've never heard of a judge warning a person, because that's what the Frampton's all about, is you're warning this person. It's a nice academic exercise that all leads to the conclusion that we've all heard for 100 years in this country, that a person who represents themselves has a fool for a client.
Right.
And that's not a joke. It's a minefield for people to represent themselves, and we recognize that. I'm not familiar with a proceeding where we would actually go into those risks, because the second they say, I have a lawyer or I want one, judges typically are like, fantastic, good. Let's get a lawyer in here to help you, because otherwise we're going to have pleadings like we see here.
I was not there, but all I can say is the record says she was advised of her rights and penalties.
I know, but usually that means you have a right to have a lawyer. That's my point.
Is it
Judges,
a penalty to have a lawyer? I'm not following.
no, it's a good thing to have a lawyer.
Okay.
But what I'm saying is that arraignment or first appearance advisement of rights, to my experience, never includes advising the persons of the risks of proceeding pro se.
Well, I can only take the court at its word when it says.
Well, do you have anything in the
rights
record? It says she's advised of her rights.
and penalties.
Well, the penalties is usually the potential sentence for what you've been charged with, not the penalty for not having a lawyer. You think penalty means the penalty for not having a lawyer?
I don't. That's why I'm saying when it says advise of the penalties, I think it's talking about what the possible penalties in this case.
The sentence, right? Possible
Right.
sentence, right. So that's kind of my point. We're not, that reference you're pointing to does not, to me, indicate that the Frampton factors, the dangers of proceeding as your own lawyer, were explained to her at that point.
Okay. And the court may be right on that aspect. What I'm saying is she had a firsthand view to the whole proceeding. She watched as her lawyer conducted oral arguments on the motion in limine, watched as he did opening statements, direct examination, cross-examination, closing arguments. So she saw all those things that are involved in the trial, saw those things that are brought out in the Frampton colloquy, and I think that with that firsthand view, that she was sufficiently advised of that.
But that comes back to my earlier question, though. That would be about the trial component of this.
All right.
So then, what is it that shows that she understood the particular risks associated with proceeding pro se at sentencing?
I mean, if I could jump and ask a
All right.
supplemental question. Most lawyers, not most, but there are a bunch of lawyers who don't even understand that the rules of evidence are different in a sentencing hearing.
Rules of
Then
evidence don't apply in a sentencing. hearing. It's
Exactly.
privilege.
Did she understand that? Did she understand that? Well, they don't apply for the most part, but you can still argue some points. But my point is that shift, would she have understood that evidentiary shift?
I don't think she would have necessarily understood that shift. I don't think she necessarily would have been restrained by that shift because she was, she's described as a nice old lady. She is the most fired up, determined person I've ever met. She doesn't let anything bar her from giving her opinion, from giving her position. And to say that she was prejudiced at this sentencing, the state takes great issue with because she was given no jail time. She was given a fine, community service, less probation than normally is given in these types of cases.
Are you saying there's a harmless error aspect to a failure under the Sixth Amendment to advise a defendant of their right to be represented?
I'm sorry, what?
Are you saying this is subject to harmlessness analysis, this particular violation?
Yes, I am.
And do you have a case for that?
I do not have a case for that. But I don't see any prejudice in this case. I think the court bent over backwards to help her in every respect.
Well,
In fact,
let me ask you a question about that thing. So I take the point that you're making, and it's well taken, that she does seem to have a very strident personality. I'll give you that, but there's something of a two-edged sword to that as well, as has been discussed with respect to the third issue in the briefing. She files a number of post-trial motions in which she makes some rather unusual arguments, invoking Jesus and so forth, with respect to the judgment of God and so forth. And one would think that an attorney would probably not be making those kinds of arguments. Fair?
fair.
So when the judge then gets to sentencing and he points out that I think the phrase he used was her attitude was not helpful or her behavior was not helpful. If we're looking for prejudice, why isn't that the prejudice? Why isn't the prejudice here the fact that she was making arguments pre-sentencing that seemed to have aggravated the judge a little bit that an attorney would not have made? Why is that not the prejudice?
Well, I think you don't see the prejudice because you don't see the prejudice come out in the sentencing. The sentencing in no way reflects any prejudice. If the judge was feeling prejudice or anxiety toward what she was doing, he took every step to not punish her in the sentencing because it's simply not there. She was given probation, 48 hours community service. I believe it was a $200 fine. This is not something where the judge is punishing that person. In fact, Mr. Turner talks about, well, why wasn't the other case filed? The other case was filed, and I inherited a different caseload. Somebody else inherited this one, and when I talked to him and asked him, well, why was this one dismissed? Now we're going through a trial, you didn't even go forward with that one. He's like, yeah, I made a mistake. Judge Walton pressured me into doing that. So I don't see the prejudice. Certainly that's not on the record, but I disagree with the whole premise of these prior bad acts weren't filed. They were. We did have another case, and that was dismissed largely in part to Judge Walton. And I don't know if the court's even going there, but I just want to...
Did you make a harmlessness argument in your brief with respect to the Sixth Amendment issue?
I don't believe I did.
Okay. So can you do that now?
Well, my harmlessness argument is that there's no prejudice by her being self-represented in this case. I think in one respect, I think she was benefited by that. She was successful in firing the judge. She was successful in firing the defense counsel. That's something in my 20-something years of practice I've never figured out how to do. There's lots of times I'd like to do that. She was successful in doing that. She was successful in getting a sentence where she had no incarceration. I think she should have been incarcerated for her conduct, which was continually attacking Cindy Law, taking every effort to harass her, and she receives no incarceration
I mean,
for
in
that.
theory, there was still a better sentence that she could have gotten, right?
There was a better sentence that everybody could have gotten, but
So if your argument is that no harm, no foul because she didn't go to prison, I think her response in rebuttal is going to be, sure, but I could have gotten a shorter probation term, or I could have gotten no community service, or better yet, I could have filed competent post-trial motions that may have been granted and may have resulted in a reversal of the trial. So why isn't that the prejudice?
well, again, the prejudice isn't there because those motions that she filed wouldn't have even been heard, wouldn't have even been proper had she been represented by counsel. So she was able to argue those motions. She was able to get all those attacks in because she didn't have counsel representing her. Otherwise, Rule 11 wouldn't have allowed that in. As far as the whole 404B evidence, the fact simply is undisputed that she was in violation of the stalking injunction, which required her to be 20 feet away.
Is that true if she in fact did not recognize the purported victim when she walked into the room in the library? Is that still true?
So, that she was in violation of the 20-foot, yeah, she was 15.7
What if she
feet.
didn't know that the person was in the room? Is she still in
Well,
violation of the statute?
that's exactly why the state used the 404B evidence, and that's exactly why the 404B evidence is proper, because it goes toward intent. There is no other issue in the case except for intent, lack of mistake, because Deborah West herself acknowledges she was 15.7 feet away. And as far as the intent, we also have the video showing Deborah West going in, and who comes out of the building of that room first? It's Cindy Law, the victim. So Deborah West doesn't make a mistake and leave. What happens is she comes in the room, Cindy says, look, you're not supposed to be here. Oh, you can't talk to me because of the stalking injunction. She totally flips the stalking injunction on her head. Cindy Law has to leave because she continues to put her poster up after knowing that she's in the room. So this is a matter of intent.
But when I asked Mr. Turner about that, he said that that's the dispute of fact, that there's something of a she said component to that. Is he
Right.
wrong about that?
That is disputed as far as that, but that's the intent issue. The intent is, well, I just went in there, I didn't know what I was getting into, and it's a matter of mistake. I was mistaken that she would be in there, or I never would have gone. But again, that's what 404 evidence is for. There's no propensity here. There's no, she did it here, so she did it in this situation. This is, what was she thinking? And those things go toward what her thinking was, what her mentality was when she was in that room, when she didn't leave the room, forcing Cindy Law to leave the room instead. Thank you.
Thank you, Mr. Weeks.
I'd like to go back, if it's okay to, and kind of what he just ended on, what Mr. Weeks just ended on the 404B, and redirection it back through the lens of, did the court abuse its discretion by not granting the motion, in limine and motion to continue? I've never been as frustrated as I was in trying to prepare for this and trying to wrap my brain around the propensity box and the intent box. I think they are just so parallel in a case like this.
But why isn't it
Welcome to our world.
Yeah.
Why isn't it mistake, though? I mean, 404B...
Why isn't it mistake?
Yeah, 404B lists mistake as one of the appropriate uses of such evidence. And if your client's principal defense was, it was a mistake to walk in the room, I didn't know that this person was in the room, and then it turns out that she keeps walking into rooms where this person is in the room, why is that not directly at issue with that allowed use under 404B?
Yeah, I think I focus on intent because I think that was what was brought up the most.
Sure.
But you're correct. Mistake was also included in
Yeah,
the
so why is that
briefing.
wrong?
I think it's because if you look at the outside incidental other acts that they're alleging here specifically, again, if it's mistake, they have to prove that those other, they're trying to show that those other acts are not mistake, and she has a propensity to try to violate this stalking injunction. And when you look at the acts, and again, I want to clear the record, I was not aware that there are other charges. If something was dismissed in another case, it's not in this record. So I'm not trying to confuse the court. I may be confused on that issue. It didn't appear as though those encounters amounted to a crime. Otherwise, why
But
wouldn't
they don't have to amount to a crime to be used under 404B, do they?
They don't have to be amount for a crime. They're just other acts. So you're absolutely right about that. But if they're just other incidents that, yeah, they are in the same community, they go to the same church, and they're stacked on each other, to a lay person, to me, let alone a lay jury member, I don't know how you don't see the propensity there. That's like the shining light.
That's not the guiding star. I recognize that the Utah Supreme Court's case law used to say that if it appeared that the primary purpose for offering the evidence was propensity versus 404B non-propensity, that you needed to kind of look at that, and if the primary thing was propensity, then it's out. Thornton, they ditched that completely. They said if it has an equal propensity and other aspect to it, we don't parse that anymore. As long as there's any non-propensity reason to look at it, the trial court, in its discretion, can let it in. Isn't that the law?
I guess I looked through, this felt a lot more like Gallegos, I think I'm saying that name correctly, where these incidences did not appear to be criminal, and the only reason to bring them in would be to show a propensity to want to violate the stalking injunction, when that's not the question before the jury. The question before the jury is, did she have the intent, or was it a mistake in the library? Not, did you ever bump into her at church? Did she ever come bump into you at the potluck? To me, it's just too close of a call, and I still think you have to weigh whether or not that, you can't just say mistake, intent in response to a motion in limine. There actually has to be a basis, and you have to weigh that. I believe that's still the...
No, it still has to go through the filter of
analysis.
403,
Yeah.
right?
And I think you also, the 403, so you have the 404, the 402, and the 403. Our argument is, not sure the relevance, because these are just happenstance encounters, and stacking those up seems to show that you're really just doing that for propensity's sake. And then that's what triggers the 403 issue.
To show that your client's not telling the truth when she says that she doesn't recognize the victim when she walks into the room. I mean, if she's repeatedly bumping into her in all these other settings, then
I don't know that was argued.
One of those, it weakens that inference just a little bit, doesn't it?
I don't know that that was argued. I don't recall that being argued on the record or in the brief. I'm not saying that's a bad argument.
It may have been a good one. I don't know.
If there's anything else?
No. Questions?
All right, appreciate it. Thank you.
Thank you, Mr. Turner. Thank you, Mr. Weeks, for your arguments today. They were great. We appreciate them very much. We will take this matter under advisement and render a written decision as soon as we can.